Hello, I'm Mashood Iqbal and I'm a barrister at London V Chambers. Today I will talk about court judicial review, that's the judicial review against the upper tribunal's decision refusing permission to appeal against the determination of the first tier tribunal. I'm sure that some of my solicitor friends would find this presentation much interesting because recently the administrative court has criticized some of the solicitor firms for substantive preparation in court judicial review claims. The process for court judicial review starts when the first tier tribunal refuses to grant permission to appeal against its own determination, and thereafter, for second chance, an application is made directly to the upper tribunal seeking permission to appeal. If the upper tribunal also refuses to grant permission to appeal against the first tier tribunal's determination, then this is called an excluded decision, which means that no further application seeking permission to appeal can be made to the Court of Appeal, or there is no alternative remedy against this decision. If there is no alternative remedy against any decision, then an application seeking permission for judicial review can be lodged in the administrative court. Therefore, in this case, the judicial review is made against the upper tribunal. The Home Office can and rather should be added as an interested party to such a claim. In order to lodge this claim, one must first of all remember the limitation period, which is 16 days, and it starts from the day when the upper tribunal's decision refusing permission to appeal was sent. So it's wise to keep a copy of the envelope saved in which you received the decision by the upper tribunal. Thereafter, an application form N461 needs to be completed. That's easily downloadable from the internet. Grounds of judicial review need to be drafted, and also with the grounds you have to attach the decision by the Home Office, determination by the first tier tribunal, first tier tribunal's decision refusing permission to appeal, and the upper tribunal's decision refusing permission to appeal must be attached with the application. Once the application is lodged in the administrative court and a claim is issued, it must then be served on the Home Office as well as the upper tribunal within 7 days. Thereafter, both the upper tribunal and the Home Office have 21 days to file an acknowledgement of service. Even if acknowledgement of service is not filed, then the High Court judge, a single judge in the administrative court, will decide your application for permission for judicial review on papers. If permission for judicial review on papers is refused, then there is no right to make an oral renewed application in the administrative court. Rather, an application can be made straight to the Court of Appeal within 7 days, seeking permission for judicial review against the upper tribunal's decision refusing permission to appeal, and also seeking permission to appeal against the administrative court's decision to refuse to grant permission for judicial review. One must remember that the threshold for granting permission for judicial review is high. It's a second appeals test, which means that there has to be either an important point of principle or practice or some compelling reason to hear the claim. Supposedly, the administrative court grants permission for judicial review on papers. Thereafter, both the upper tribunal or the Home Office have 14 days to request an oral hearing. If a request is made, then the matter is to go for a substantive hearing. And if a request for oral hearing is not made within 14 days, either by the Home Office or by the upper tribunal, then the administrative court quashes the decision of the upper tribunal refusing permission to appeal. Against the quashing of the decision, either party can seek permission to appeal from the Court of Appeal. That can be the Home Office or the upper tribunal. Now, that application to the Court of Appeal itself is a complex procedure for which I shall do another presentation on another occasion. For the purpose of this presentation, that is it, and I will see you next time in another presentation. Until then, take care, goodbye.